Thank you very much for the floor. It is with love and respect that I welcome you today, and I also respectfully thank for the opportunity to participate in this conference and that I can talk about the legislation in the past decade, and I can focus on the topic of criminalization. And the spirit that I will approach the topic is very similar to the spirit of Professor Todt. The title of my presentation requires some explanation. It includes typical and atypical reasons for criminalization. And by way of introduction, I would like to say that the classification that I am using is not a scientifically worked out system of classification that is up to the highest professional or scientific standards. I make no such claim. And I think what we consider typical and atypical is something very relative. So I am only giving you some guidelines, some guidance towards this goal, and I'm sure there are many different sorts and categories of classification. So this is just for you to know. Professor Todt shared with us some very detailed figures. I think you mentioned 55 amendments. I remember 51. It may be more, but suffice it to say that we are talking of more than 50 in any event. And more speakers yesterday also said that when we bid farewell to the previous criminal code, it already had more than 100 amendments. But compared to that, it's not very fortunate that in only a decade we reached half of that number. I also made other calculations, and one regards the number of recently criminalized crimes, and this is 21. This is at least according to my calculation. And I ventured to make this calculation, as you can see in the slide, and this is what we can confidently conclude as a result. However, a significantly higher number is the number of recently criminalized behaviors. It is a methodological issue how we can count that number. I did not want to venture into such depths, but one thing is certain, that the real figure is significantly higher than the 21 that features in the slide. And if you look deeply into potential classifications, you will see that the number one reason is the changes of criminal policy. I am sure that it also is the case in the Central and Eastern European countries that spoke yesterday. In such cases, the legislator and the Ministry of Justice uses its sovereignty to change the legal political direction or legal policy direction, and as a result of this change in criminal policy, it identifies new crimes, and I highlighted two. One is Chapter 19 concerning crimes against sexual freedom, where serious substantial changes have been implemented. Most recently, crimes against children were reformed, and dramatic stricter legislation was introduced, and child pornography was also subjected to to stricter sanctions. And for the sake of our foreign colleagues, I would like to mention that virtual child pornography is also punishable according to the new policy, when we are only talking about animated content, not real children. And another change in criminal policy can be captured in the area of corruption crime. It was mentioned several times yesterday as well in the case of healthcare, in the relationship between physicians and patients. Gratuity money is now very seriously punishable. Now, after the policy changes, the second priority is given to And maybe it should be the first reason in my list, but it is EU changes, and it also affects our entire region. We could say that we are all in the same boat. For example, the falsification of medications, human trafficking, money laundering. Money laundering was mentioned several times yesterday, and the EU's position on that, abuse of personal data. Just remember the EU's GDPR directive, which is in the background of all this, and terrorism financing also belongs to this picture. And as a general remark, allow me to say that we are observing increasing pressure on the legislator concerning the transposition of international commitments. So the EU criminalization obligations are being expanded all the time. So what we feel and observe internally, domestically, is also reflected in the international arena. And that transposition is extremely challenging. Yesterday, the first Hungarian Criminal Code, the Csemegi Code, was mentioned. This is our tradition, this is our background. It has its roots in the German criminal system. And in addition, or confronted with that, we have the English statute law being the foundation of these new international requirements. And the reconciliation of the two is very challenging. And it is, in fact, a special profession to do so, how we can transpose all this into our Hungarian law. And the verbatim transposition is maybe not the right way forward. But as I said, these new crimes represent a serious challenge. In my slide, I am also mentioning changes to background norms. There are many framework dispositions in the Hungarian Criminal Code, and it brings about a necessity because the related changes in the background norms are also reflected in the Criminal Code. For example, the law on weapons or the law on assembly have all changed recently, and under these circumstances, the amendments to the Act on the Criminal Procedure are also reflected in the Criminal Code itself. In the fourth place, I have the fourth reason, that is addition of more behaviors to particular crimes and making legal consequences more stringent. I have not even dared to count the number of more behaviors added. I just highlight a few examples: the abuse of new psychoactive substances, or when a person escapes from prison, when today it is not only from prison, but also from police custody that is considered a crime, and fraudulent behavior related to taking out a patent is also classified as a crime, as a most recent development. And ultimately, I have this very general trend, which is in my slide, and it is not only in the past decade, it is already in the past 20 or 30 years that we have seen the proliferation of such behavior, and it is in part related to our international obligations. When the Criminal Code of 1978 was approved by Parliament, I remember I counted only 8 crimes were punishable for their preparations. And when we said goodbye to the previous code, instead of 8, we had almost 50. And I must admit that in the new code, I have not even counted the number of preparation behaviors to commit a crime. And indeed, it is a methodological challenge to count the number, but all I want to say that the number is very high by today. And in the last place, I have the attempt to influence the practice of the courts. And this is indeed inscribed in the Hungarian Code. It could be called an atypical reason when messages between the legislator and the system of the courts is not working in the way that was envisaged by the legislator, and in such a case, a legislator takes to legislation. So, for example, in the case of the abuse of data, the legislator took to legislation to influence the prosecutor. So it's also a very interesting story to look at budgetary fraud and the number of counts that can be committed of this kind of crime. And the legislator solved the issue by amending the circumstances of homicide. So, from a methodological perspective, this might not have been the best solution. And in terms of atypical, extraordinary circumstances, let me first emphasize or highlight the truly extraordinary circumstances. There are two fundamental societal crises that have happened, and they have not yet been brought to an end. And these trends have influenced the criminal legislation significantly. And the first one is the migration pressure, and it has been the case since 15, and the dramatic increase in the number of human trafficking cases was mentioned yesterday as well. And within that, new facts were included in the criminal code. But I want to stress that from a statistically significant perspective, it is only the forbidden crossing of the border and the damaging of the physical fence that are, to be included in this case. And the other phenomenon was the COVID pandemic, where the legislator took to the amendment of the criminal code. So a new fact was included, trying to prevent pandemic protective measures. That was the one, and the other was to spread false information, hampering the protection against the pandemic. And there were some concerns as to whether the freedom of speech is being restricted by this new fact. And the good news is that no such procedures have been launched in practice. According to the most recent information that I have, in the territory of the capital city of Budapest, 50 such criminal reports were made, and in 47 cases the report was rejected, and in 3 cases a police investigation was launched, but they were terminated. So no indictment was made at all within Budapest. So we can conclude that the freedom of speech does not seem to be in danger from this new amendment. But on the other hand, we have this symbolic product in the criminal code, I believe, and its practical implementation will simply not happen. And then on the other hand, the falsification of immunity certificates is another case that was included, and I will discuss it in more detail later. And on the top of my slide, I have ad hoc legislation, and our Croatian and Slovakian colleagues mentioned this yesterday when case law codification is taking place. In many cases, it is followed by heavy media coverage. We are talking about individual specific cases or events in society, and the insertion of these cases in the criminal code is very far detached from our current traditions and practice, and we can see some really strange developments. For example, one example is the false image recording, which is capable of destroying the good reputation of a person, or the second is driving ban under the effect of prohibition to reside in a particular area. So this was intended to criminalize certain individual cases that happened in society and that were heavily covered by the media. And very briefly, I would like to talk about some constitutional cases. From Justice Zine, yesterday we heard a presentation about this area, and I would like to highlight as a very positive development that the practice of the Constitutional Court became solidified in the area of a direct, the possibility to make a direct complaint in these cases. We thought that this would never happen because in the past it always happened through the courts, but I believe it is a fully rightful approach that whenever we see recently criminalized behaviors, in relation to such behaviors, we do not yet have a criminal practice in the courts. So we do not want these to have a chilling effect on society. As a result of this, the Constitutional Court opened up the possibility of direct complaints, but this only is the case in recently criminalized behaviors, at least in current practice. And by the way, the slide includes facts related to COVID pandemic and immigration cases, illegal migration cases. And Professor Todt also mentioned another phenomenon, namely that we have a government decree concerning the falsification of COVID immunity certificates, and this decree includes stricter measures than what is included in the criminal code. And the decree also included new behaviors. The Constitutional Court has not yet conducted an investigation into this situation, but I believe that the Constitution does not allow for government decrees introducing new behaviors. So if a case will be implemented and the court will make a condemnation, then it may happen that the issue will be brought to the Constitutional Court in the future. And towards the end of my presentation, I would like to mention that too many fragmented, small-size amendments are undermining the coherence of any criminal code. The ultimate goal was coherence in 2012, but if we have so many amendments, obviously the coherence will be undermined. And I think Mr. Chuck yesterday mentioned that it is always a question what we have with the existing legal objects and the new legal objects. Especially in case law legislation, we have observed that the legislator was simply unable to insert the new behaviors in their proper place in the criminal code. So, for example, driving ban under the effect of a prohibition to reside in a particular area has been put in the wrong place in the criminal code. And when somebody is attending a prohibited assembly, that's also an interesting issue. Participation in a prohibited assembly is representing a case of sanctioning something in public administration law, and it was put in the wrong place because it is now included among crimes violating freedom, or disclosure of falsified recordings that are capable of destroying the good reputation of a person. And the intention of the legislator was to maintain confidence, public confidence in the transparency and of general elections. And it is also put in the wrong place, in my opinion, because it should be included in the anti-libel part of the criminal code. And Article 28 of the Constitution expects the legislator to be able to place the new behaviors, new parts of the criminal code in the proper place. So I think it is to be expected from the legislator also on constitutional grounds. And I'm looking at Professor Mihai Tóth, and once a year, with a friendly smile, you usually remark that I overestimate the role of legal objects. And sometimes I am inclined to believe that you are right. And such individual legislation has also brought about another issue, too many subsidiarity norms being included in the criminal code. And this is happening frequently, although they understand that there are abstract facts of the case. So the causistic cases are supplemented by a subsidiarity clause, and this has become quite proliferate in the criminal code. And in some cases, the subsidiarity form meets the alternative form, and the legal consequence of the alternative form is higher than of the former. Mr. Chak yesterday spoke of similar cases, and he mentioned the Delphi future-telling place in ancient Greece, and I believe that we are approaching that point in Hungary with regard to this. So in my opinion, the entire criminal code should be reviewed. And yesterday we spoke of money laundering and the receiving of stolen goods. Mr. Banati already highlighted a related problem, and I would like to focus on the chapter in the criminal code concerning crimes against the freedom of sexuality. And with regard to child pornography, I want to direct your attention to a most concerning development, especially in the protected age, that is below 18. People below 18 are punished very strictly, and this is a regulation dysfunction. And there are disproportionate measures. And just one example for them, if there are two 16-year-old classmates and one enters into a sexual contact with a child of 13, that is not viewed as a crime under the present criminal code. However, the other 16-year-old person, if he makes a single photo of this sexual act, which is not seen as a crime, then that person who has made the photo is eligible for a 5-year imprisonment under the circumstances that a real sexual contact is not punishable between them. I think we have to find a very fast solution to this issue. We have to re-regulate the current situation for the people below the age of 18. And there is one more aspect that I want to touch on very briefly. I would like to mention that it is a welcome development and the number of registered crimes is decreasing. And I just want to highlight one conclusion in these terms. If in the criminal statistics the number of crimes is dramatically decreasing, however, the new criminal measures are being increased all the time. So I think the conclusion lends itself that in most cases these are just symbolic criminal measures. Thank you very much.